What you are spending, yes, is significant. What you are saving in the long run is I mean, there's no number on it. There's no number on being able to pass a legacy to your loved ones.
Teach me something, Uncle Money.
Hey everybody, today we have an estate planner. Now, a lot of people say, I want an estate plan. I need to get an estate plan done. But my goal today is to really understand what it's like. So when you're thinking about an estate plan, you'll be more prepared as you move forward. So today we're joined by Whitney. She's an estate attorney. Thank you for joining us today.
Thank you for having me.
Whitney, if you don't mind, kind of explain, who you are, your firm, and the type of clients that you serve.
Yes. So my name is Whitney Knox Lee. I am a licensed attorney here in Georgia. I've been licensed for 11 years and have practiced in a variety of areas, including civil rights law, public benefits, housing, and landlord tenant. My firm is focused on estate planning. And so we help people get wills and trusts for the purpose of preserving their wealth, building wealth, making sure that their loved ones, their children, have inheritance if that's what the client wants, and really just making sure that the legacy is staying intact. So I work primarily with Black and Brown individuals and with first-time estate planners. And so often we're using language in the legal field that people don't understand. And so I love really kind of simplifying, breaking it down, working with my clients to make sure that they're understanding the documents that we're putting in place. And not only that, but they're understanding how to use them and how to communicate to their loved ones about using them.
That's good. That's good. So let's start off with some definitions. So when we say estate plan, it's a loaded term. People say things like generational wealth. You need to make sure your heirs are taken care of. But as we know, estate plan actually has a lot of different elements. So in general, what is the estate plan, and whether the specific documents are pieces of an estate plan to actually make your estate plan complete?
Yeah, thank you. And I think before even talking about the documents, let's talk about what is an estate. Because many people think that in order to have an estate plan, you need to have some multi-million-dollar estate. But when we use the word estate, we're talking about just all the things that you have worked hard for. We are talking about money and bank accounts and real property and other assets, but we're also talking about heirloom items. We're talking about those recipe books or intellectual property if you are a content creator, or a podcaster like myself, and you have a library of electronic content, or if you are an artist and you have paintings or photos or whatever it is, all of that is a part of your estate. And so then when we talk about what is estate planning, it is protecting and preserving everything that is within your estate so that it goes where you want it to go after you pass away, but also so that as you age, your family and your loved ones know how to care for you and what kind of decisions that you would want made. So the key documents to a comprehensive estate plan include your power of attorney documents. So it can be a durable power of attorney, which is just kind of a general, I give somebody the power to make all sorts of decisions. There's a healthcare power of attorney. There's a financial power of attorney. And so both of those are specific to healthcare and to finances. There's the last will and testament. And then there's the revocable living trust. I will note that it's really important as well for people to be considering their beneficiary designations in their retirement plans, in their life insurance plans, keeping those up to date, as well as long-term care planning. So maybe getting long-term care insurance or otherwise planning on how you're going to afford to continue to age. And life insurance is another big one.
I like that. I like that. People don't realize how many documents there is and how comprehensive the estate plan actually is. in your experience, what are the triggers that somebody may seek an estate plan in your practice? And also, when should people be thinking about getting an estate plan completed?
So the common triggers include after having a baby, or maybe when you are expecting a baby, after or around marriage, after or around retirement, and then as you age. So a lot of people will start thinking about it at 65 or older. Um, they'll start thinking about wills. Um, I like to tell folks when you turn 18, you can start estate planning. And really, maybe you don't need a will or a revocable living trust, but you do need a power of attorney document because, especially for parents of children going to college, once somebody turns 18, parents no longer have a say in that child's care. They no longer have access to that child's bank accounts. They cannot help to manage funds, or, they just really don't have any authority. And sometimes the child doesn't want that. So, like, I was one of those children that was like, I'm 18, I'm an adult, I can do all the things myself. I don't want you in my business. However, I do encourage parents to talk to their 18-year-olds or their children that are going off to college about logistically, how is it going to work if you need help? How is it going to work? Because the answer is I'm going to need some kind of legal document that's going to give me authority to know about your healthcare and to know what's going on with your finances. And those are the healthcare and the financial power of attorney.
Yeah, I think a lot of people do not take time to think about the healthcare aspect of it.
Mm-hmm.
Um, what have you seen as far as, like, what are some stories or examples where, because this document was not in place, that the person could not receive adequate health care or the
Yeah.
health care
So,
they didn't wanted?
and keep in mind, this can happen at any age, which is why 18 is a good place to start, at least for the power of attorney documents. So what can happen is you're out driving, you get into an accident, and now you are needing to be hospitalized.
Mhm.
And maybe you are in a coma, or maybe you're not able to communicate because of some other reason. You're still with it, like you're still conscious, but you're not able to communicate. If you do not have a healthcare power of attorney, then the doctors are going to look for just anyone who knows you. They're going to look for the next of kin, may or may not be able to find the next of kin, and the doctors are going to have to make decisions based on what they think is best. And especially as we age, we may have specific ideas about life support, for example. If we are observing certain religions or religious traditions, we may not want some types of healthcare, like blood transfusions or skin grafts. And if we can't communicate that and we don't have legal documents communicating that, then we may get some of these treatments that we don't want. So the healthcare power of attorney really helps not only to say, okay, who is the person who has authority to make these decisions when I can't, but also what kinds of treatment that we want or do not want.
Like that, like that. So let's say one of those trigger events happen, and or somebody turned 18 and now they're an adult and they have to think about other things that their parents used to automatically be able to do, but they can't do. So I'm preparing to get an estate plan done. What are some of the documents that I need to be thinking about, preparing statements, even just thinking about decisions that I value and my principles? What are some of those things I should consider?
Definitely consider the powers of attorney, and the will, at least, at least. Depending on what your goals are for your estate and for your legacy, you may also want a revocable living trust. And so I will go into each of those in turn. A will is great for if you want to determine who gets what after you've passed away. A will is also vital for parents of minor children because the will indicates who you are selecting to care for your minor children if something happens to you and their other parent, or if they don't have another parent, if something happens to you. So in your will, you're making what's called the guardian designation. Now, the court ultimately is going to determine who is going to be the long-term guardian. So when you're making that designation, you're offering to a future court who you want to be the guardian. If you do not have a will in place and you are a parent of a minor child, what's going to happen is your loved ones will need to petition the court for guardianship of that child. And they will be arguing. Usually this is grandparents arguing about who is the best situated to be able to care for these minor children. So a will is really important, whether or not you have children, though, because again, that is the document that is going to allow you to determine who is getting what. If you do not have a will, here in Georgia, the state has an estate plan for you. So if you don't have an estate plan, you actually do, and it's determined by the state. We have what are called laws of intestacy, which are the laws that take over when somebody dies intestate or without a will. So the state will determine who gets what, depending on what your family makeup looks like. So if you have a spouse, your spouse automatically gets your assets. If you have a spouse and children, your assets are split up in specific ways between your spouse and your children or your child. If you don't have a spouse and you don't have children, the laws of intestacy continue to go down the line as far as your family members, to your parents, then to cousins and siblings, and so on. So if you really do not want a specific person in your life to inherit from you, then it's important to have an estate plan. If you are married and have not legally gotten a divorce, but you're separated, it is important to have an estate plan. If you have minor children, it is really important to have an estate plan. The revocable living trust is helpful because it also handles incapacity. Incapacity meaning you're not able to make decisions for yourself because of maybe a medical condition or injury, because you disappeared for more than 30 days, because you were incarcerated for more than 30 days. Any of those instances or occurrences are considered incapacity. And a trust allows you to appoint someone else who is going to manage all of your assets that have been funded into the trust. And then in the trust, you also have beneficiaries. So you are still naming who should receive your assets in the event that you have passed away.
So let's say I need those documents, all the documents more than likely. What are the documents that I need to put together before I meet with you? Like, what should I be putting out? What should I be thinking about? What should I be writing down, jotting down some notes? What are those steps that I need?
Yes. So at the point where you go to an attorney, you should be prepared to give names and contact information of all of the key people in your life. When I say key people, I mean anyone who you want to be a beneficiary, so who you want to receive your assets, anyone who you want to be a guardian, either of yourself or of children, anyone who you want to handle your finances on your behalf or to make those healthcare decisions on your behalf. You should also know approximately what your assets are. So you don't need to know down to the penny, but you should know if you have life insurance and what the policy value is and with what company it is with and whether it's a term policy or a whole life policy. You should know if you have a retirement account and how much money approximately is in it. You should know if your beneficiary designations are up to date. You should also have ideas about healthcare, about what you do and do not want, about life, about, why am I blanking on it? Life support, sorry. You should know what your thoughts are on life support. Maybe you don't quite know whether or not you want life support. but you know that you wouldn't want to be on life support for 6 months, or you would want your family to keep you alive long enough to say goodbye to your relative, like so that people could fly in from other states to be able to see you and say goodbye to you. So you should have ideas about all of those types of decisions.
Let's say I have selected an estate attorney. I have these documents. Before I talk to an estate attorney, what should I be communicating to my family, my loved ones, people that may be affected by me creating this estate plan?
Yeah, so there is going to be potentially some strategizing. Well, let me take that back. There's always going to be strategizing with your estate plan. That is what the attorney is helping you do. And that is the difference between going to an attorney or doing a DIY or a chat GPT estate plan is the strategy. Because attorneys are equipped to be able to tell you based on your goals and objectives and your family situation, what the best options are for you to accomplish those. So, as far as families are concerned, sometimes multiple family members might own one piece of property together, or maybe the family has talked about goals that the family has as far as their wealth is concerned. So it is important to talk to your family members just about, what the plan is, what is the family goal. If you are in a marriage and your spouse and you have different ideas about what should happen with any assets that you all have when you pass away, then you will want to be clear with each other. And it doesn't have to be the same. That's fine. You guys can have separate estate plans that have different goals, but you'll want to be clear with each other on just what that is, because it might impact what you put in your estate plan versus what your spouse puts in their estate plan. You should also have conversations with family members about your health care, because at the end of the day, these are all pieces of paper, but you want there to be additional context for the people that are helping you to make these decisions when you can't, and for the people that are going to be managing your affairs after you are gone. So you want them to understand why you made the decisions that you made. You want them to understand why you do or you do not want life support. You want to communicate with them what your opinions are on these things so that they can then relay that to the doctors or to the bank or whoever to make sure that what you want is actually what you're going to get.
Now, let's talk specifically to kids. Let's talk to minor kids and also adult kids. What are those type of conversations that should be having before they even come see you?
Mm-hmm. So it's difficult to have conversations with your children about estate planning because, of course, no child wants to think about their parent no longer being there or about having to care for their parents. So again, what is likely is that adult children at some point in their lives will need to care for their parents. So having the conversation about what you want that care to look like. Do you want to age in home? Or do you want to be at a nursing home or an assisted living place? And how are you going to make that happen? Do you currently live in the same state as your adult child? Or might you need to relocate to be closer to your adult child so that they can support you as you age? What money is there? What resources does the family unit have to be able to support an aging parent? Or alternatively, what resources does the family unit have to be able to support minor children, particularly if you are a single parent? And okay, great, you've chosen a guardian for your child and you've had the conversation with the guardian. You should tell these people, tell your agents and your guardians and your executors and your trustees that they have this role within your estate plan, because they may say, nope, I don't want it. I do not want this. And you will need to pick somebody else. But when you're considering who are going to have these key roles in your estate plan, like a guardian, consider whether or not they can afford to be your child's guardian. Are you leaving them enough money to be able to raise that child? Because children are expensive. Do they have a relationship with that person? So those are the types of conversations that we need to be having, whether or not we have an estate plan and over the course of time, because some of these decisions are going to change based on changes that happen in life.
So let's pretend like, okay, I've decided on the attorney, I have my documents, I've had these conversations. Now I'd approach an estate attorney. Explain the typical process or maybe your process on onboarding a client, getting them through the process. What is that like? What should somebody expect when they meet an estate planner?
So you can expect that your first contact with an estate planning attorney is going to be either a workshop or a seminar or a consultation. Um, estate planning attorneys, some of them have specific types of cases that they will take and other cases that they will not. It's important to know that there are estate planning attorneys, there are real estate attorneys, and then there are elder law attorneys. An estate planning attorney, myself, we help you get your affairs in order. A real estate attorney is dealing specifically with property, with real property. They are helping with buying and selling real estate. Real estate attorneys might also be estate planning attorneys, but they're not necessarily estate planning attorneys. For example, I work with a real estate attorney because when I'm doing trusts, I need assistance with the real estate attorney transferring title of a home into the trust. And we'll talk about trusts. And then there are elder law attorneys. Elder law attorneys are specialized in that long-term care planning piece. They are specialized in being able to help you sort through whether or not your family is going to need Medicaid and how to protect your current assets, like your home, from Medicaid estate recovery. So it's important that if you are older, if you are in your 50s, that you start speaking with an elder law attorney about how to protect what assets that you currently have. Now, there are elder law attorneys who are estate planning attorneys, but you just got to be clear on the type of attorney that you need right now. So going back to your question, as far as what to expect, the first conversation is going to be a workshop or a consultation where you are getting more information about what specifically that attorney does, and they are getting information about what you need. From there, they will be able to tell you, okay, yes, we can work together, or nope, sorry, I don't handle elder law, or I don't handle real estate transactions, so I'm going to need to refer you out. Sometimes that initial consultation is going to have a fee. And that is because if we didn't charge a fee, then we would be speaking to everybody for free and never having clients, because essentially we know that people want information and may not be ready to invest in an estate plan. So I will also note that there are a lot of free opportunities to get this information. I would take advantage of those before engaging with an attorney, because at the point where you engage with an attorney, you should be ready to move forward with an estate plan. So you should be ready to pick what you want and then dedicate the time to actually complete the tasks that the attorney gives you. And you should be prepared to be able to pay. Okay, so consultation or a workshop or a seminar of some type. From there, you will sign an engagement letter, which is the contract of services. That is the document that says, okay, the attorney is going to provide these services for this fee. The fee includes whatever it includes. In Georgia, it is standard practice for estate planning attorneys to have a flat fee for the services, as opposed to charging hourly. Now, this is different for probate. A probate attorney is somebody that is representing loved ones who are now probating the estate of somebody who has passed away. Sometimes that's a flat fee if it's an uncontested probate, so nobody is arguing about anything. Other times it's an hourly fee. Okay, so look for estate planning attorneys that have a flat fee. where everything is included so that you can be prepared as you are paying that bill. After that engagement letter, you will make your payments. Most attorneys do not accept payment plans for this. And when we're talking about payment, we're talking about $2,000, $3,000, $4,000. So I do accept payment plans up to 4 payments over the span of 4 months, but most attorneys do not. After that payment is made, you will have at least one design meeting. And that is where you will meet one-on-one with your attorney and you will actually go into detail about what you want to happen within your estate plan. And then the last meeting, well, there may be a document review meeting where you will receive a copy of the drafts of your documents to review. You will have an opportunity to make any corrections or changes if you find any, or if you think of any. And then the last meeting is the signing ceremony where you will sign your documents. This all can happen within 4 to 6 weeks. Sometimes it will take longer, but our goal as estate planning attorneys is to get you through and get your documents signed. Because up until you sign the documents, you don't have the estate plan.
What is usually the bottleneck that may extend an estate plan longer than that 4 to 6 weeks?
Usually it's people not being prepared to make the decisions that they need to make, which is why I say coming into your engagement with an attorney with an idea of what you want to happen. Now, obviously, while you are working with the attorney, you are going to be learning more about the documents, about what's possible and what's not possible within an estate plan. You might get some new information that is going to change your mind as to what decisions that you need to make. But usually the bottleneck is a feeling of overwhelm with the weight of the decisions. And so I just encourage people to move through that because if you don't make a decision, then the state is going to make a decision for you.
You mentioned there's some free resources out there. Would you like to shout out any free resources that you recommend folks look at, observe, read, consume, ponder before they come speaking to you?
So just Googling estate planning attorneys in Georgia, I welcome folks to go to my website, willsforthepeoplega.com, because I have blogs, I have videos, I also host monthly webinars, and I'm out in the community giving free seminars almost weekly. And most attorneys have some level of education that they are providing for free. So when you're Googling attorneys, you can go to that attorney's website and read their blog posts or watch their videos or attend the free webinars and take notes. And that's also a good time to evaluate whether or not you think you can mesh with that attorney because you'll be able to get an idea for what that attorney's personality is, what that attorney's process is, and potentially what that attorney's fees are. But do know that sometimes you will not know what the fee is until you've actually had a consultation. And that is because the fees are going to be highly dependent on your specific circumstances and the type of package that you want. And so when I say package, I mean if you want a will-based estate plan or a trust-based estate plan.
So you said this a lot. So there's wills, power of attorneys, trust, but because I think the thing that confuses a lot of folks is the difference between a will and a trust. Can you kind of speak on the differences between those two?
Absolutely. So a will is a good starting point. It is better than nothing. But where there's a will, there's probate court. So there are some key downsides to a will because although you have started your estate planning process, you've decided who gets what when you pass away and who the guardians for your minor children are going to be, your will has to be probated in court. And so what that means is after you have passed away, your executor, the person who you have chosen to manage your affairs when you're gone, they will need to petition the probate court to probate your will. They will have to go to court. They will need to fill out a petition. There's a process in which they will need to publish your death, news of your death, in the local newspaper so that they can notify any potential creditors that you might have that you've passed away, to give those creditors an opportunity to make a claim against your estate for any debt that you might owe. The judge is overseeing everything that happens in probate court, and your executor has to report to the judge what they are doing as far as they're going through the administration of your estate. So what I mean by that is administration of estate means paying your debts, doing a accounting and inventory of your assets and appraisal of your assets, and then distributing your assets according to your will. And then nothing can happen until the judge says it can. So key downsides is that if your loved ones are not able to navigate that process on their own, they will need to hire an attorney. That expense can easily range between 1% to 7% of the value of your estate. So if you have a $500,000 estate, your loved ones may end up spending up to $5,000 or more just on legal fees associated with getting that assistance. Because when you're thinking about it, your executor is grieving while they are going through this process. Your executor may or may not live in the state where you passed away in, and they may need to travel to that state in order to probate your will. Another thing about wills is that they're state specific. So if you have a Georgia will, but you pass away in Florida, your will needs to be probated in Florida, where you've passed away, not where you've spent your entire life living. And because your will is based on Georgia law, there may be some complications in terms of how your will is probated and whether or not the people who you want to get your assets will actually get to have your assets. And so that's a big deal for executors. Also, probate can take a long time. Here in Georgia, at minimum, you can expect a year in probate. But I've spoken to families who have been in probate for 4 years. And during this time, the assets are kind of frozen unless there have been other ways for these assets to pass outside of probate court, like through beneficiary designations or payment on death designations or joint ownership. These assets will be frozen. So say, for example, you are in a long-term partnership with someone and you have a child. You are the owner of the home that you live in. Your partner is not. You pass away and you do not have a will, or even if you do have a will, your partner and your child are living in this home that now ownership is in limbo because the home has to pass through probate. So if it's a 3-year probate process, your partner doesn't necessarily own that home while they're going through the probate process. Your other family members may try to recoup that home because it's money. And so it just opens up, that wait in probate court can really create a lot of complications for families. And then the last thing about a will that especially parents of minor children need to consider is that a will does not allow you to have conditions on inheritance. In other words, when you pass away, your beneficiaries will receive their inheritance outright. This is not a big deal if you are older and your beneficiaries, your children, are 30 or 40. Okay, maybe it's fine that they get the $100,000 life insurance policy outright. When your children are minors, what this means is that they cannot receive that inheritance. It needs to go in a trust or it will go to the guardian. If your children are 18 or 21, they are going to receive all of that money outright and all of those assets outright. And there is nothing that is going to help them manage those funds so as to be able to use those funds over the course of their life, like many of us might want our children to be able to do. So if you're someone who you want to leave someone $25,000, but you don't want them to be able to access it until they are 25, then you need a trust to do that. So trusts are basically wills on steroids. A trust is a legal contract that you create as the trust maker. And it determines not only what happens to your assets, but also when. And so there are three relationships in a trust. There's the trust maker, there is the trustee, and then there's the beneficiary. For revocable living trusts, you are all three of those. Up until the point where you become incapacitated, so you can't make decisions for yourself, you've disappeared, or you're incarcerated for more than 30 days, or when you pass away. At those 2 points, the successor trustee steps in. And that, again, is somebody that you have appointed. They are then managing any of the assets that are in the trust. And to get an asset in the trust, you have to change the title of the asset. So for a home, that means retitling the home from a home owned by Whitney Knox Lee to a home owned by Whitney Knox Lee as trustee of my trust. If your asset is not funded into the trust, then the trust does no good. And you still have to go through, your family has to go through the probate process. What a trust allows you to do, though, is create subtrusts for the people that you want to inherit, where you can say, this person gets $100,000, but they only get 10% of that when they turn 21. And then they get another 10% when they turn 25. You can say, this person has to complete college in order to get their inheritance. Or this person has to, take a financial literacy course before they can get their inheritance. You can have conditions on it. And when somebody's assets are when a beneficiary's assets are in that subtrust, while they're there, they are protected from that beneficiary's creditors. And so that is really important for people who are concerned about maybe a future divorce for their child, and they don't want the future ex-spouse to receive any of their money. A trust is a way to be able to avoid that. So I know that was a long answer, but what I didn't say, trusts avoid probate. So this is, one of the main reasons for a trust. You do not have to go through the probate process. As long as your assets are funded into the trust, those assets pass outside of probate. So instead of it taking a year to 3 to 4 years, it takes a couple of weeks. Also, the expense, you're not having to pay an attorney to represent the family in court. So that 1 to 7% value of your estate that you might expect to spend in probate court, you're not having to spend that anymore when you have a trust.
Gotcha. Thank you. Thank you for the explanation. So let's say the client has a complete estate plan done. Now that I have this paperwork, these documentations, I've done the pre-communication, what type of post-communication do I need to have to friends, family, those who are affected by this will and estate plan?
So I would go ahead and let those key people in your estate plan know their role. You might give them copies of these documents. You might not, you don't have to. At the very least, you want your executor or your trustee to know where to find the documents if they need to access it. In regards to power of attorney documents, you can give your healthcare providers and your financial institutions copies of those documents so that when the agent, the person that you've decided is going to help you manage your affairs, when that agent needs to be able to rely on the power of attorney document, it's already on hand with the medical providers and with the financial institutions. I do usually recommend that my clients give their agents copies of those documents as well. But there are times when you may not want to do that. Maybe you don't want that person to be able to use it until some point down the road. So maybe you just don't want them to have that document. But definitely having the conversations with the people that like, okay, my estate plan is in place. This is your role. Thanks.
So we give the people who need a copy of the document, but for our copy, how do we keep it safe? Like, have
Yeah.
you seen people do to make sure if something were to happen around them that their documents are safe?
So there is a misconception that with a will that it needs to be filed at probate court. It does not need to be filed there. It can be, but it's really just for safekeeping. It's just another place to keep your will. So wills can be filed there. I do just suggest that all of the documents are stored in a secure place, whether that is in a safe within your home. Some people will put them in safety deposit boxes. I recommend against that because then you have to make sure that the people who you need to have access to it have access, which can be difficult when it's in a safety deposit box. So I suggest a safe or a fireproof bag, or other fireproof container. I am aware of people who keep their stuff in the freezer. And so it doesn't have to be fancy, just some place that will be safe from theft and also from fire or flood.
So we have this estate plan completed. When do we need to update the estate plan? What are some of those things? We talked about triggers that trigger somebody needing an estate plan, but what are some triggers that somebody needs to update their estate plan? What type of life events? What happens when somebody has to come back to you to complete an estate plan?
Yeah, so those same triggers of like getting an estate plan are also good triggers for updating. So if there's a new child in the family, whether through adoption or birth, or well, yeah, adoption or birth, divorce or marriage, um, maybe relocation, potentially if you have a will, you might want to get a new will that is based on the state law for the state that you've now moved to. If you come into a lot of money, you may need to update your estate plan because there are going to be specific strategies that you'll use depending on the amount of wealth that you have. So if your wealth has shot up, like one, good for you, but two, you will want to speak not only to an estate planning attorney, but also to a financial advisor, to a tax consultant, etc. Um, uh, Purchasing a home is a good time to update an estate plan as well because you want to make provisions for what should happen to that asset after you've passed away.
That's very good. Now, this is a segment of the video where, I take my own medicine. What, based off how you've worked with clients, do you feel like financial planners miss the mark? How can they serve the people that you work with better?
I just think the communication. Um, so I would say when you're obviously, yes, recommend that people have estate plans. The more that you know, though, about specific attorneys who do estate plans, I think the better you're going to be able to assist your client because you can make referrals based on fit. But you can also say, okay, I know that Whitney is not an elder law attorney, and this person probably needs elder law planning. So let me, one, be able to explain why elder law planning is good for this person, and then two, make that referral. I think two, being upfront about the investment. A lot of people come to estate planning attorneys expecting to spend $500. You can't really get any documents for $500. Many estate planning attorneys, our hourly fee is $500. So that it is an investment. And so also talking to clients about saving for an estate plan. as we are, saving for our emergency fund, as we are setting aside for travel, as we are investing, we also need to have a bucket. Like if we do not have an estate plan, there does need to be a $3,000 to $5,000 bucket specifically for legal fees associated with estate planning.
Now, for the last question, make your best sales pitch. So somebody's looking to get a estate plan that's going to be multiple thousands of dollars, in a minute or less. Why should somebody invest in their estate plan?
Yes. So we like to think about the things I like to save money, right? I don't want to go spend top dollar for something that I don't have to spend top dollar for. There are circumstances though where I definitely want to spend top dollar. That is on like a fire extinguisher. I don't want a dollar store fire extinguisher because I want to make sure that the fire extinguisher works when I need it. A parachute. I don't want a parachute from a secondhand place. I want a parachute that I know doesn't have holes, that is brand new, that has been tested. And so estate planning is similar. The investment is not an investment in documents. It's an investment in the expertise of the attorney and the strategy behind your estate plan, because not everybody needs the same estate plan. And what you're getting, if you're not planning at all, or if you are doing a DIY or a Susie Orman or a whoever, is a standard estate plan that is going to be applied to your circumstances. And that may or may not be what you actually need. You might need, and in fact, you do need something that is specifically tailored to your circumstance. And you don't know because you're not an estate planning attorney. You don't know what needs to be tailored to you and what doesn't. You don't know what this general language means and how it's going to impact the ability for your family to receive their inheritance. So it is really important to make this investment. What you are spending, yes, is significant. What you are saving in the long run is, there's no number on it. There's no number on being able to pass a legacy to your loved ones. And at the very least, the $2,000, $3,000, $4,000 you're going to spend with me is less than what your family is going to have to spend after you've passed away and they're having to go through the probate process.
Great. Now, if somebody's listening and say, hey, I need to get this done, been wanting to get this done for a long time, what is the best way to connect with you?
Yeah, so on my website, there's a variety of, contact me boxes. You can email me at whitney@willsforthepeoplega.com. You can find me on Instagram at willsforthepeople, and you can call me 770-203-2047. My process is that when people reach out to me, I do schedule that first consultation. I do have a fee. Sometimes that fee is waived according to different promotions. If you're not able to pay the fee, a good first step is to view one of my webinars, go to one of my seminars, get that information for free. And then when you are ready to move forward, reach out.
Awesome. Well, thank you very much, Whitney. You've shared a lot with us. Hopefully this interview, put somebody at ease if they're thinking about getting an estate plan. Really just say, okay, I know what to expect. I know how to move forward, and I can anticipate what's going forward. So thank you very much for your time.
Absolutely. Thank you.
Take care. If you've been inspired to leverage your practice to create financial freedom, please schedule a consultation with Diesel Wealth Management. The legacy you dreamed of is a 15-minute phone call away from becoming a reality.
The more I know, the more money I can make.